Good afternoon, my name is David Wilson. I'm a partner here at Digby Brown LLP, and I'm also a solicitor advocate, and I'm going to talk today about the changes in the Sheriff Court rules. This is the Act Sederant 2009 that came into force on 2nd November 2009. There are four main changes to the Sheriff Court rules, and I'm going to look at the first one, which is Simplified Pleadings. Now, for years we've had pleadings in the Sheriff Court which have got more to do with war and peace than actually what pleading should be about, and that is giving fair notice to the other side of their position of a relevant case. Now, what the Act Sederant does is it gets back to the basics to produce simplified proceedings, a brief account of what the case is about. Now, you'll see in the Act Sederant at PI1 there is a style for simplified initial writs, and you'll see that the initial writ is split up into 6 paragraphs. It's very straightforward. Paragraph 1 is the identity of the pursuer, paragraph 2 is the identity of the defender, paragraph 3 is jurisdiction, paragraph 4 is a brief summation of the facts, usually not more than 1 or 2 paragraphs, is setting out the facts of the case. Paragraph 5 deals with the quantum side of things, something that you'll all be familiar with, fairly similar to the paragraphs that we already have now, though the big change is that you've got to name the doctors and the hospitals that have treated the pursuer. Finally, my favourite paragraph, paragraph 6, deals with the law. Gone are the huge long paragraphs setting out various learned documents from the 19th century about industrial disease. All you have to say is that if it's a common law, you just have to say it's common law. If it's a statutory duty, all you've got to aver is that it's a statutory duty, which regulation you intend to rely on, and which paragraph of which regulation you intend to rely on. It's as simple as that. With regards to defences, all that's expected is paragraphs mirroring the initial writ. Obviously, if there's any substantive defence, such as preliminary proof on time bar or contributory negligence, fair notice of the relevant basis of that case has to be averred. Adjustments are as before. And finally, the last thing I'd remind people is that in terms of the existing ordinary cause rules, you still have to deny the other side's case. If you fail to deny something that is within your knowledge, then that's held to be an admission. And remember, not known and not admitted is not a denial.